To you all. I'm Giovanni Zazzerini. I'm the Secretary General of ISME, the International Network for SMEs, an association working at international level set up by the OECD and the Italian Ministry of Economic Development 20 years ago, with the main goal to foster innovation in favor of SMEs. The association indeed gathers key innovation stakeholders at international level. Nowadays, we have 64 members from 34 countries worldwide, and all the organization, public and private, and the association have something in common. They work in developing policies and programs in favor of entrepreneurship and SMEs. Today, we are going to start a new initiative founded and supported by the European Union Intellectual Property Office, with the main aim to raise the awareness and understanding on IP issue in favor of small and medium-sized enterprises. With our partner and ISME members, De Tullio and Partners, represented here by Elio De Tullio, who will lead the webinar on IP and internationalization. Just a few housekeeping rules. You can ask questions by using the chat box, and I will collect all the questions coming from you, and I will redirect to Elio at the end of the webinar. This is the first webinar on IP issue. As you can see, it is a journey we designed in favor of European and international SMEs. The next webinar will be on brand management, so with a strong focus on trademarks, the 10th of July, and the others are mapped in this picture, but you will be informed properly during the next few weeks. Just final remarks that as agreed, we will be able to release a certificate of participation if you are able to attend 4 out of 5 webinars. So please stay with us and provide us with your valuable feedback to improve and to deliver properly this training course. Now I leave the floor to Elio De Tullio, founder of De Tullio and Partners, and IP, well-known and renowned IP expert working at international level for us, and also ISME board member. Please, Elio, the floor is yours.
Well, thank you very much, Giovanni. It's a pleasure to be here, to have so many participants and to start this journey together with ISME and the project founded by UIPO. UIPO will be mentioned several times in my presentation, so I will start now with my presentation. Just a quick housekeeping rule. Please close your micro during the presentation, so all the participants can enjoy the listening. I assume that you can see my screen. Can you confirm?
Yes.
Okay, great. So let's start with IP, intellectual property. My name is Elio De Tullio. I'm an Italian lawyer, attorney at law and trademark attorney, founder and managing partner of De Tullio and Partners. De Tullio and Partners is a partner of this project. Among the others, I'm one of the experts of UIPO, WIPO, and other institutions. I'm also a member of the board of ISME since 2015. what does IP mean? Intellectual property encompasses creations of human mind, inventions, literary and artistic works, images, brands, design. We will see several examples of intellectual property rights, and you will see how different are they. So you have names, but you have also new plant varieties, you have geographical indications, you have semiconductors. So during our path, we will focus mainly on title rights, so those rights that are submitted to a filing registration process, so basically patents, trademarks, and industrial designs. But we also have copyrights, and we will also mention copyrights, and we will see the differences between copyrights and the other titled IP rights. Intellectual property means exclusivity, means monopoly. So it's a legal protection for all is the product of innovation and creativity. It's the regulation of fair competition, but also it is a protection of consumers, because in most of cases certifies the quality of products and services. But it is also the creation of an economic incentive to invest in knowledge creation, so the possibility to, let's say, to have something that can attract the capacity of entities to produce innovation and creativity. Here we mentioned some of the characteristics of intellectual property rights. So once again, they are exclusive rights, they are monopolies, so they allow the owner to use the products and services in exclusivity. They are enforceable rights, so once they are protected, they can be enforced before courts, before customs, before other authorities, in order to be protected against infringements and other kind of violations. There are also flexible rights. They can be assigned, they can be licensed to third parties for internationalization purposes, and they can also be co-owned, so you can file the application together with other parties. So in this case, you have co-owners, co-applicants of title IP rights. But they also have an economic value. Here you can see the IP contribution study carried out by UIPO and EPO. UIPO is the EU Intellectual Property Office, our, let's say, founder in this project. EPO is the European Patent Office with head office in Munich. They carried out this study. The first edition of the study was in 2013, and the results of this study are quite surprisingly. The focus are IPR intensive industries, so those industries having an above average use of IPR per employees, and most of the industries are considered IPR intensive in European Union. And the study demonstrates the real contribution of IP rights to the European economy, and we will see in the next slides the IPR intensive industry generated around 30% of all jobs in European Union in the 3 years, 2017, 2019. Around 40% of all employments in European Union are generated by IPR intensive industries. They are also the main contributors of the GDP, the increasing of GDP in European Union, with 50% of the GDP due to IPR intensive industries. They are also the most active importing and exporting company in European Union. 90% of exporting and importing companies are considered IPR intensive industries, and they are also able to pay, you know, higher salaries to employees with a premium salary of plus 40%. For instance, this SME that is also mentioned in the UIPO website, if you go to this section of UIPO, Ideas Powered, you can find a lot of successful cases of SMEs, European SMEs, that started to grow up and to let's say, scale up the level of their business due to inadequate management of intellectual property. This Lapopsi is a Slovenian company that specializes in producing frozen treats made from real fruit frozen on a stick. They started to protect their IP, and then they concluded an agreement with SPAR in Slovenia. So due to the protection of their intellectual properties and their brands in particular, they then expanded to Austria and other EU countries. And so this move allowed Lapopsi to grow up and to increase its turnover. What are intellectual property? So we have trademarks, we have patents, we have industrial designs, copyrights, domain names. We will go on, the definition of these rights little by little. But if you have any question, please send the question in the chat, and we will answer you. Here you can see also some polls. We would like to see the level of awareness and the level of your business. If you are aware about intellectual property rights, if you already export products and services in European Union or in other countries. And here I can see that some of you already exported products abroad, so in non-EU countries. So trademarks are signs, but trademarks can be also logos, can be sounds or holograms or other kind of non-conventional trademarks. The important is that they are able to distinguish products and services and the origin of those products and services. So these are the two main functions of trademarks: the distinctive function and the origin function. They provide information about the origin of a product and service, and they give consumers a key message that drive their purchasing decision. So they are very important in order to, let's say, create alliances, create partnership, and create a special relationship with consumers. But it's also important to create let's say, this special relation with local consumers. So in some countries, you need to protect the trademark in local characters, and sometimes in some countries that do not adopt the Latin characters, you should also consider to translate the Latin characters in Mandarin or in other languages, local languages, like in China. Coca-Cola is one of the companies who first transliterated the trademark into Mandarin in China, using not a literal translation that was not really attractive for consumers, but using a conceptual translation, so to permit mouth to be able to rejoice Coca-Cola. That was one of the successful factors of this product in China. But you also have patents. So a patent protects an invention, so a new product or a new process or a method or a system. Patents can also protect software according to certain conditions. So provided that the software can be considered a computer implemented invention, can achieve a further technical effect, and can, let's say, match the inventive step factor. International patents, as well as international trademarks and international designs, as we'll see afterwards, are bunches of national rights, but patent rights can be enforced as well as the other IP rights before national courts. But in patents, now we have a very interesting news, that is that the European Patent Court that will manage, that is already managing the European patents with unitary effect starting from last year. Then you have designs. Design protect the appearance of a product, let's say the aesthetical part of a product, the shape, the colors, materials, or other ornaments. Let's say they are the so-called not technical innovation, but let's say how important are designs in our purchase approach. They are very important because we like very nice things. We like, let's say, the aesthetical part of products. That is why it's so important to protect designs. Designs can also protect the packaging or other shapes related to products. Then finally, you have copyrights. Copyrights are untitled rights. So let's say theoretically, they can arise independently from a filing registration process, but it is highly advisable to file an application before the Copyright Office of your country in order to reverse the burden of proof and to, let's say, have an evidence, let's say, paper evidence of the paternity of the work and the starting date of your creation. They protect all is related with literary and artistic works, but also music or videos or presentations or other, let's say, creations of your brain. Finally, you have domain names. Domain names are, let's say, considered as IP rights. Of course, they follow trademarks. They are those words between the www and .com, .net, let's say, your your homepage address. To some extent, they are protected like de facto trademarks. And we will see some, let's say, case studies on domain names in the next webinar about brand management. That is also something that can involve some consequences for domain names. Here you have a second poll. Have you already filed or registered your IP rights? So the majority of you have not. So this is a good opportunity to know more about what is the, let's say, the importance and the meaning of registering IP rights. For those of you who already registered IP rights, you will find here some, let's say, information useful for, let's say, the prosecution phase or even the enforcement phase of the management of your IP rights. You have not specified what IP rights you have filed and registered. Usually, the most common is trademark because you know, trademarks distinguish all companies, and also, let's say, the name of the company itself is, let's say, a distinctive signs, and so it falls among the, let's say, the trademark family. I will give you some other minutes to end the survey, and I will go on with my presentation. Now we will speak about some principles of intellectual property rights. The first principle is the principle of first to file. So it is very important in some countries, in some jurisdiction, to file before others an application for registration. This is valid in particular for title rights, so patents, trademarks, and designs. So those rights that start according to a filing registration process. So in order to start the right, in order to have the right in your hand, you need to file an application before a public authority at national level or the regional level or international level. And then the public authority, in the majority of cases, carries out a substantive examination of the application according to the legal requirements provided for by the law in the country of interest. It is very important to check independently, so on your own or with the support of an IP attorney, the existence of the legal requirements provided for by the law. We will see these legal requirements in the also in the next slides. But please bear in mind that novelty, so the novelty of the IPR, the potential IPR, is a factor that is in common for all IP rights. So trademark must be new, a patent must be new, or an invention must be new, a design must be new in order to be protected, registered, and to enjoy all the benefits of intellectual property rights. Then the other legal requirements are different from right to right. For instance, for the trademark, we have the distinctive capacity. For the industrial design, we have the individual character. For the patents, we have the inventive step that are, the capacity of those IPR to, let's say, to match the function provided for by the law. And this assessment should be ascertained before filing, before starting spending money, because otherwise, if the legal requirements are affected by, let's say, a low level of capacity to match functions provided for by the law, then this can be a problem when you would like to enforce your rights before a court against an infringer or against a competitor, so when you like to use the right. So it's very important to count on and to spend money on strong rights, rights on which you have carried out a preliminary assessment before filing, and let's say the main tool in order to carry out this preliminary assessment is the search. So the patent search or the trademark search or the design search are those activities highly suggested before filing in order to start the process in a virtual way. And in terms of filing, now you have very good opportunities. I don't know how long yet, because this will be probably the last year of this SME fund of UIPO. So the UIPO, the EU Intellectual Property Office of Alicante, that is the European Commission office managing EU trademarks, EU design, and also the EU Observatory that conducted the IP contribution study, launched this scheme, this support scheme for SMEs called SME Fund. In 2024, there are reimbursement for expenses for the filing and registration of trademarks, designs, and in case of patents, you can be reimbursed also for the filing and search fees and for the legal cost for patent application, drafting, and filing, up to 75% or 50% according to the country in which you will use the fund. You can also receive support of this service that is called IP Scan. This IP Scan is implemented only in some countries where the IP offices have agreed to deliver this service to SMEs. Go and see the opportunities offered by the SME Fund. You can check this link, and this is a very good good way to start the process of IP protection. You will receive an IP voucher, and the reimbursement will be sent directly to your bank account. Also, your IP attorneys can be in charge for managing this IP voucher. So it's a very easy process, and you can save a lot of money in case of trademarks, up to 1,000 euros per entity. Another very important principle of IPR is the principle of territoriality, so the geographic limitation of protection. Of course, you have regional rights, like EU rights, you have international rights, but once again, bear in mind that international rights are bunches of national rights, and you should consider this when you start any international application process. We will see more details afterwards. The other principle is the principle approved at WTO level, the World Trademark Organization, the World Trade Organization, and this principle is the principle of national treatment, a kind of reciprocity in terms of treatment between or among member states, among countries. So it provides that each state must grant the same protection to nationals of other states that it grants to its own nationals. So it's very important that intellectual property is the basis for a fair international trade, a fair competition among operators, among economic operators, and among countries. The other principles is the principle of limitation in time and scope. So each right has its own function. So patents protect invention, trademarks protect logos or signs, designs protect the aesthetical part of products, and they have different duration. Patents expire 20 years after filing. This is because 20 years monopoly is enough to recover the expenses, the cost, and the financial resources spent in research and development activities, while after 20 years, inventions become a public domain, so they become part of the knowledge of humanity and a part of the progress of humanity. Trademarks expire after 10 years, and they can be renewed indefinitely forever. They can be assigned, or they can be, let's say, given to your son, to your assignees. So they are very flexible. And of course, one of the key points and the legal requirements of trademarks is they must be used on the market. In case of no use, they can lapse for non-use. Then you have designs. Designs, the industrial design, registered designs expire after 5 years from the filing, and they can be renewed for 4 times for a total amount of years of 25 years. This is at European Union level. Sometimes the duration of designs is not harmonized at international level, so you have different duration for each country or jurisdiction. In case of design, you have also the protection of non-registered design that lasts 3 years from the first publication of the product on the web or on the market. You have different types of IP applications. Usually, the best way to start is to file the application in your country of origin or in your region of origin, because you should use the priority rights that we will present in the next slide. So you have a national registration. You can file the application in Italy, UK, in Singapore, in US, in Australia, Argentina, and this can be done before the National Patent and Trademark Office. Usually when you start the application in your country of origin, then you have 12 months priority for patents and utility models where applicable, and 6 months priority for trademarks and industrial designs. Then you have some regional registrations. There are different systems. At European Union level, you have UIPO managing the EU trademark and the EU design, and the EPO managing the European patent and the European patent with unitary effect. Then you have ARIPO and OAPI, that are two organizations in Africa, and other regional organizations that can manage protection at regional level. Then you have the international registration. You have the Madrid system for trademarks, the Patent Cooperation Treaty for patents, the HAG system for registered designs, and we will see afterwards how these systems work and what are the main characteristics. Once again, international registrations are, let's say, very good instruments because they harmonize formalities at international level, but they are bunches of national rights. So once you start the process with one single application, then this application is spread to the national offices of the countries claimed in your application, and these national offices examine the application according to their national rules, legislation, jurisprudence, and practice. So it's a little bit complicated system, apart from the first filing, and so it is highly advisable to be supported by an intellectual property attorney, a trademark attorney, or a patent attorney, in order to do not lose the opportunities connected with the use of international conventions. And this is the Paris Convention. It's the most important convention in intellectual property, dating back 1883. On the basis of the Paris Convention for the Protection of Industrial Property, the owner applicant of an application for the registration of an IP right, filing one of the member states of the Paris Convention, may use this priority period, and this priority period is 6 months for designs and trademarks, 12 months for patents and utility model, from the filing of the application in the country of origin to extend the protection of the first application in the country of origin in any other country of the world that is also a member of the convention. This can be done through an international filing in order to be protected in more than one country, or a national filing in the specific country or countries of interest. So in this way, the priority days secured the novelty of the invention, in case of invention, is safe, and third-party interference can be avoided. So let's say this is a way to give the applicant more time to decide where to extend the protection. And in case of patents, you can further extend the priority up to 30 months or 31 months from the first filing using the PCT. The PCT is the Patent Cooperation Treaty. It's a treaty that allows you to buy time, paying official fees. So this priority period for patents, in case you file a PCT before the end of the 12 months period, will be extended up to 2.5 years from the first filing. So this means that you will have around 3 years, 2.5 years, to decide where to extend, and if you like to spend more money for the protection of your invention. Let's focus now on these international systems. Why we speak about international systems? Because if you like to enter into a complex corporate operation, if you like to license your rights, if you like to distribute your products in a non-EU country, or in a country in the European Union that is not your country of origin, then you should consider to extend the protection, because even a licensing scheme, if you like to license your brand, or you like to select a distributor in a country in which you like to expand your market, has as presumption the ownership and the holdership of IP right in that country. It is the only way to safeguard your partner in case of infringements, in case of violations. So, for instance, the MADE system for trademark. It is a convenient and cost-effective solution for registering and managing trademarks worldwide. There are 131 countries, including all EU member states. So you can start the process, filing the application before WIPO, and then you can claim protection in US, China, Japan, Brazil, and other countries of the world. It's very useful because you can start the process with one filing, with one application. You can pay a set of fees in Swiss francs, and then the national offices will examine your application according to their rules, and they will issue protection, so registration, or provisional refusal, or total refusals, or other objections in case they do not agree with the existence of legal requirements in your application. If you'd like to know more about the MADE system, you can check this guide. This has been carried out and prepared and drafted by the Southeast Asia, Latin America, China, India IP SME helpdesk. It is published online. These helpdesks are initiative of European Commission in order to support SMEs in the protection of IP rights in these regions, so Southeast Asia, Latin America, China, and India. But it is a very useful guide that will give you a lot of information and hints on how to use the international system of the Madrid Agreement. This is also another case study. It is a Greek company, Greek food company, established in 1988, that according to the use of the Madrid system, started to protect the trademark everywhere in the world. During these years, the company has implemented the protection in several countries. Indeed, the international protection, according to the Madrid system, can be, it's a modular protection, so can be, let's say, extended and let's say used in order to extend the protection in different time periods. So you can file the so-called subsequent designation. You can file another application after the first application in order to add other countries to the protection of the initial bunch of countries. You can extend the protection in all countries members of the Madrid Convention, so the 131 members. All these activities allow this Greek company to register trademarks, to also to license the trademark to other entities in the countries of interest, and to enforce the rights, in particular in those countries in which, you know, let's say, scamming of trademarks or other kind of violations are very common, like Vietnam, as we'll see in the other slide. Any license agreement is based on IP, and any license agreement is based on a title IP right. So basically a patent or a trademark or a design or a mixed use of them. Of course, you can also use know-how or trade secrets or other IP rights, but these are untitled IP rights. There are kind of self-declarations and they do not have the same weight of other title IP rights, so they are, let's say, the borders, the frames of these rights are more uncertain, and so they are a little bit weaker than title IP rights. So the outcome is that this Greek company managed to export its products abroad to use the rights also in a challenging way, so trying to let's say fight against infringements. It also filed an application for seizure and for the suspension of goods before the Vietnamese customs. And so the lesson learned is that the ownership of an international registration allows companies to protect their rights, to use their rights in order to expand the business abroad, to export products and services with a certain guarantee that no violations can be made, and if there are violations, they can be challenged before local courts. The Patent Cooperation Treaty is the treaty that rules the international protection of inventions all around the world. There are 157 contracting states and this application, this system, the Patent Cooperation Treaty, allows to file a single patent application in your own country, in your language, paying in your own currency, and so you can claim protection in these 157 contracting states. So basically, most of the countries of the world. It is very important, the PCT, also when you are not sure where you would like to export your technological innovation. Sometimes the protection of patents can be a bit expensive if you are not able to plan in advance the allocation of resources. So the use of PCT allows you to, let's say, to to carry out and to draft a business plan, a correct business plan on the protection of your invention. So you can, let's say, extend the priority up to 30 months from the first filing, and so that you can extend, let's say, the nationalization phases until this is possible. In order to file a PCT, you need to pay official fees for around 3,300 euros. But this is, you know, a good amount if you consider that in this way you can extend this priority and you can have additional 18 months to think about where to go, to think about where to extend the protection, and in which countries would like to spend money for the substantive examination of your invention before the national IP offices. The other system is the international HAG system for design. It's a little bit less popular with 96 countries, but you can register up to 100 designs using this HAG system. Bear in mind that the use of this HAG system, as well as the use of the other international systems like the Madrid system, the PCT, is not really easy. So once again, even in this path, it is highly advisable to be supported by an IP attorney. So at the end, what opportunities can IPRs offer businesses? They can allow you to increase reputation and competitiveness in the market. As to trademarks, you should consider the protection of trademarks in some countries like Risico. You need to occupy territories as soon as possible, preferably before your products and services become very popular and very successful, because otherwise it will be too late. So let's say, trust your business, trust your innovative project, because and start protecting your trademarks, your IP rights before it becomes successful, because otherwise it will be too late. There are also good return on capital invested in research and development. This is in particular for patents, designs, and utility model. So before, when you start research and innovation in your company, you don't know if you will achieve or not a good product. So probably you will invest a lot of money without knowing in advance if your product will be successful or not. So once your product is made, once you have a prototype, even before the prototype, you can file the application, so you can enjoy 20 years monopoly in case of patents, or 5 years monopoly extendable for designs, so you can recover all the time and financial resources spent on research and development. For copyrights, you can exploit the results of creativity in case you create a content, you create a literary work or audiovisual work, and you can enjoy protection for 70 years from the death of the last of the authors of the copyright work. They are also able to make you improve participation in collective entities. You can file collective and certification trademarks. We will not examine collective and certification trademarks in this webinar, but if you are interested, please post a question in the chat, and I will speak about collective and certification trademarks in the next webinar. But they are very important IPRs. Even if you like to, let's say, to establish a startup, to set up a spin-off. So in this case, a patent or a trademark or a design can be one of the key factors in order to establish the startup or the spin-off, and can be one of the ways to attract potential investors, business venture, business capitals, or business angels, or those who would like to invest money in your project. They are also a way to boost the growth of export capacity. They allow you to target products on new markets, because of course you need to think about what is, for instance, the sign or the name that can attract consumers in a specific country or countries. And so, let's say, to the extent you manage to achieve this goal, you will be successful in that country. There are also ways to support the internationalization of SMEs. IPRs are the basis of any joint venture or technology transfer agreements. If you like to enter into one of these legal schemes, it is highly advisable to have your IP registered. So in case of due diligence, you can show that your business has been enough protected. They allow also the development of new markets. Once again, any licensing scheme is based on IP. You should declare in your licensing contract that you are the owner of the IP right, that your IP rights are valid. There are no problems or pending proceedings on your IP rights, because you should guarantee the licensee about the genuinity and the clearance of your rights. In these slides, I summarize some peculiarities of IP rights. Before doing that, I will launch this third poll. So have you ever encountered problems in registering or enforcing your IPRs? Of course, we would be happy if you like to share these problems with us. Probably we can give you suggestions about how to afford them and how to overcome them. Most of you haven't encountered programs, one of you mentioned the legal costs. So this can be an issue, how you can, let's say, found your IP protection and enforcement. I already mentioned some supporting scheme for SMEs, but now in a few minutes, I will give you also other suggestions. Thank you for this, for these answers to the survey. So what are the peculiarities? So the process normally starts with an application filed before a public office. In US, you have the USPTO, you have UIPO, UIPO, you have also WIPO. WIPO is the UN agency managing the international conventions. So when we spoke about the Madrid Convention, the Patent Cooperation Treaty, or the Hague Convention, they are all managed by WIPO. So this receiving entity, this receiving institution, then carries out an examination. Sometimes it's substantive, sometimes it's only formal, and then gives you an answer: registration, no registration, or objections, or others. Protection is accorded on territorial basis. We already mentioned this. The effectiveness of the protection, so the defense against third parties, depends on the proactivity of the right holders. You have a lot of possibility to be proactive. You can activate a surveillance system. You can control the market. But in any case, if you see something wrong with your IP rights, you need to react promptly, because otherwise this will be considered a kind of tolerance, a kind of acceptance of the infringement. And so it will involve some legal consequences. So in case you see a violation and infringement, please, let's say, make a plan and in order to react, because otherwise you will be considered that you are accepting the situation. So if requested worldwide, the protection may be costly, but can generate a lot of revenues. As you have seen in the previous slides, the majority of the successful companies in European Union, I mean the so-called IPR intensive industries, started with the protection of IP rights. So they are able to generate benefits for themselves and for employees and for all the, let's say, all the environment around. So it's very important to consider protection of IP rights. So this is another case study. This is a small company, medium company based in the south of Italy. They have several trademarks in the sector of pipes and pipe fittings, polypropylene, copolymer random, and they are used to transport water basically under pressure, with also a kind of system of irrigation drop by drop. There are also one of the companies listed in the Ideas Powered as those companies who benefited from the SME Fund in 2023, and they are very active in protecting their IP rights at the national and international level. Usually the classes of interest are 11, 17, and 19, and they had some problems in China with this trademark Toro. The application was, let's say, refused because there were several similar trademarks in the registers. Please bear in mind that the CNIPA, the China National Intellectual Property Administration, also carries out an examination of novelty of trademarks. So if in the registers there are similar trademarks to yours, they can issue provisional refusal. So that is why preliminary searches before filing are very important. In this case, one of these trademarks was filed by the distributor of the Italian company, and then you know, the usual excuse of these distributors in China, but also in some Southeast Asian countries, is we did this in order to help you, because according to them, the national path can allow the registration of the right more easily and in a faster way. This is not true. The international system, the MADRID system, allows the protection and the registration of rights under the same conditions and with the same legal protection of national rights. So in this case, there were then some warnings, some discussion, and at the end, the trademark registration was assigned to the legitimate owner, and so the Italian company managed to have the right back and to go on with its business in China. So at the end, preliminary searches are really very important because they are, let's say, the legal guide. They are the guidelines for, let's say, understanding the closest prior art, trying to see if your sign, your invention, your design match with the legal requirements provided for by the law, and sometimes the data collection can be also carried out independently by the SME, but it is much better that you are supported by an IP attorney that can support you, not in the data collection, that is also very important, but in the interpretation of data according to the relevant jurisprudence, case law, and practice. On this purpose, you can also enjoy the pro bono support for SMEs. This is another service provided for by UIPO. So if you go to this link, you can find a list of providers in Italy, but also in all European Union member states. So IP firms that agreed to give some time of availability in order to support SMEs and to provide pro bono services for any IP need. You can receive this pro bono just filing an application. So please consult this the UIPO website, and you can get additional information on pro bono providers. WIPO also is offering an IP management clinic. So if you go on the website of WIPO, the World Intellectual Property Organization, and you digit IPMC, like Intellectual Property Management Clinic, you can get SME, you can get, of course, you need to file an application. You can get a free IP, let's say, management clinic on your IPR. You can receive a report about your IP protection strategy. For each IP right, you have different classifications. In particular, for trademarks, is very important because it is mandatory, so it determines the scope of protection. So you need to select products and services among 45 classes, 34 of products and 11 of services. For instance, if you like to protect your trademark on e-commerce platform, you need to consider class 35. That is not really intuitive. Or if you like to protect your products in the metaverse or for virtual goods, you need to consider class 9 and class 41, and others, of course, like class 35. So it's not really, classification became harder and harder, so it's not easy to afford. There are some tools, even on the EUIPO website, that facilitate the classification for independent users, like TM class. But even in this case, if you are supported by an IP attorney, he or she will be able to give you some suggestions about how to, let's say, identify the right classes. Indeed, bear in mind that if you file the application for class, for instance, class 9, let's say, technical devices, electronic devices, and then you forget to protect your trademark also in class 35, then you need to file again the first application, paying again the initial fees for the first class that are higher than for the remaining classes. At the European Union level, the fees for the first class are 850 euros. For two classes are 900 euros, and for any additional class are 150 euros. So if you forget to claim a class in the first application, and you need to file again the first application and pay again the amount for the first class. For patents, the classification, it is only a hierarchical system that allows the selection of specific field of interest from general headings in case of patent searches. So they are not mandatory, but they are very, it is very useful to be able to navigate among classification codes, international patent classification codes, or cooperative patent classification codes, in order to carry out proper patent searches. And for designs, you have classification according to the Locarno classification. Even in case of design, classification is not mandatory. Finally, some tips and tricks. Some of them were already mentioned during the presentation. Before starting the last two slides, I would like to ask Isme if there were any question in the chat. Let's see. Yeah, okay, no questions. So it's very important, a preliminary assessment of legal requirements to be carried out before the first filing at national level or before the EU filing. The preliminary assessment is a key point in order to be prepared to go further with your IP protection. Understanding the legal framework is also very important, above all if you go to different jurisdictions. And even if you get information, these informations are not enough to implement the actions. For implementing the actions, it is better to be supported by experts. Priority problems means saving money. So if you like to save money at the very beginning without performing a search, so you are not saving money. You are probably wasting money in the prosecution phase. So it is better to make a plan before filing, so thoughts before acting, This is crucial for your IP path. IP is a kind of business plan. You need to put resources in the right boxes in order to be prepared to afford any occurring problem. So on one product, it is possible to have different IP rights, so you can enjoy multiple layers of protection. On one product, you have a patent, a trademark, or a design, or a copyright, and more IP rights you have on your product, more protected is the product. Once again, it is advisable to select IP experts based in the country of origin or in the region of origin of your protection. Then he will take care of your of the extension of your protection even at worldwide level, liaising with let's say national, local attorneys in the country or countries where you like to extend the protection and where the applications are filed. It is always better to have a tailor-made approach according to the size of the company, the sector, the objective of the SME, the budget available, the possible solutions. So there is no one solution fit for all. It is always a tailor-made approach that should be privileged. So it's very important to consider that a deep study of your situation is a key point for building up a proper IP strategy. Sometimes, if you like to, for instance, this is a very peculiar case. If you identified a trademark and you like to launch this trademark at worldwide level, and then you see through your trademark search that there are similar trademarks in the database or similar trademarks already on the market that can interfere with your rights, then you can also opt for negotiating the consensus, negotiating the authorization to use that trademark, the similar trademark, for your purposes, according to the payment of royalties, for instance. So in order to reduce and mitigate risks to receive a cease and desist letter, in the meantime, your promotional activities has started. So it's very important to reduce risks, to mitigate risks before launching products on the market, because otherwise you can also suffer, for instance, the seizure of products. The counterparty can ask you to withdraw the products from the market with very serious legal consequences. The allocation of annual resources for IP protection and enforcement is a crucial point. IP rights allow, let's say, a multi-annual plan, a multi-annual budget, so everything can be predicted. So I mean, of course, there are some costs that cannot be predicted, like opposition by third parties or litigations, but the cost for prosecution can be predicted to some extent. So it is very useful to make a plan. Bear in mind also that there are different validity requirements for patents, trademarks, designs, copyrights. So we already said that novelty is one of the validity requirements that is in common for all IP rights. But for patents, for instance, we have the inventive step. The inventive step is the capacity of this solution, your innovative solution, your technical solution, to be, let's say, something beyond the state of the art. Let's say a complex solution that solves complex technical problems from the point of view of an expert in the field. And so these legal requirements, validity requirements, should be analyzed in depth by your IP expert before filing. A preliminary assessment of infringement before sending any form of communication to the counterfeiter should be done. So if you see a counterfeited product on the markets, don't panic, but just go to your IP attorney and start and prepare a strategy, because the first thing to avoid is to send formal communication to the counterfeiter. First of all, you need to collect evidences, to collect proofs of the infringement, and to collect proofs that can be usable in a courtroom. And finally, in terms of valorization, I mean, we discourage the use of templates like NDA or licensing contracts. It's not advisable because those templates are made by somebody using some words, and they defend the position of one of the parties. So it is always better to involve an IP expert to draft your own template fit for the purpose and you know, with a tailor-made approach. And the final slide is about the key recommendation for the internationalization of SMEs. So select your international strategy according to a preliminary assessment based on investigation and searches. Assess the state of the art around your product. So try to see what is around, what is the state of the art. This is a good way to convince examiners of IP offices, but also to have, let's say, a clear space of action in case you have problems with your competitors or other third parties. Start protecting your IPR before entering the market. Prepare a 3 to 5 years budget to protect and exploit your IPR. Carry out novelty and inherent protectability searches at worldwide level. Verify possible third parties' rights, and if necessary, request authorization. So take care of your first filing. Don't forget that if you file the application in your country of origin or in any other country, you have 12 months priority rights that can be extended in case of patents. So, I mean, the first filing is very important. If you make a mistake in your first filing, then this mistake will involve further mistakes in the other applications, and your, let's say, protection will be affected. Collect all orders, invoices, receipts, and other documents that can be used in, for instance, in a court proceeding. Do not forget to manage the ownership of IPR with respect to partners. If you have a licensee, you should, let's say, preserve its position, and so you need to be careful. Plan in advance the possible exploitation of your rights projects, because you can do that. You can plan in advance what you are going to spend. Monitor markets and competitors' behavior. So in case you are entering into agreements with third parties, try to see who is on the other side and try to see what is its behavior in terms of respect of intellectual property rights. And there are some, let's say, database that can be used for this purpose. Activate through your IP attorney a worldwide surveillance system. You can monitor what happens in records worldwide. If somebody else is filing an application for protection of a similar trademark, even in Macau or in Argentina or in Canada, so you will be, you can be informed in real time, and you can be prepared to file an opposition to registration or a cancellation action. Monitor IP gazettes and be ready to react by filing possible administrative and legal actions. I was exactly meaning that you need to be prepared to file oppositions or cancellations, and verify the compliance of contracts that provide for local legislation as applicable law. So if you are negotiating and entering into an agreement with a third party based in the other part of the world, bear in mind that if, for instance, the Chinese is the applicable law, you need to understand in advance what are the consequences of this applicable law and what you can do in China. Sometimes in China, for instance, you can use evolved and upgraded versions of NDAs in order to protect your rights in case of a change of information, like NNN, that are called non-disclosure, non-use, non-circumvention. Usually, they provide as applicable law the Chinese law, and as competent court the Chinese court, because they are, let's say, already validated by Chinese authorities. So that's all. I hope you enjoyed this presentation. Of course, I'm available for any follow-up, any question, any even, let's say, consultation you would like to receive further to the contents presented today. If not, next time we will speak about brand management. It's very important. It is focused on trademarks. How to select a good trademark, how to carry out proper search, how to avoid infringements, how to survey, to monitor the market, and how to react in case of illegitimate use on search engines or e-commerce platforms or other digital environments. Here you can scan this QR code for a satisfaction survey. Don't hesitate to do that. In the meantime, I would like to thank you all. You have already read that there are let's say, five plots of this journey about the protection of IP rights. You will have brand management next time. Then you will have IP infringements. We will focus on even on cases of IP infringements in other countries. Then we will also study and present the licensing schemes and the technology transfer, and of course how to evaluate your intellectual property rights. They can have a value. They can be used for any objective of your company. So it's very important to know that protecting your IP is a way to increase the value of your company and your assets. So thank you very much. I remain at your disposal for any further need.
Thank you very much, Elio, for such interesting seminar. A lot of things, and I believe that several points will be better explored during the upcoming webinars. I have a question on a topic you touched during your presentation. The feeling is that several SMEs from the furniture industry are starting an international journey. Could be afraid of how to better protect their design. And at the beginning of your presentation, you mentioned this point, and I would like to ask you which is the the step-by-step process to protect a design and for a small business.
Well, thank you, Giovanni, and thank you for to those who posed this question. Of course, it depends on the products, because sometimes for SMEs the cost of protection are perceived high. So in case of design, you can enjoy also the protection given by the non-registered design. The non-registered design is a right granted by EU legislation, giving the owners the possibility to be protected for 3 years from the first publication or divulgation of the design on the market. or disclosure of the design on the market. Sometimes the non-registered design can be a good tool to start the protection. Otherwise, but this is only for 3 years. So if you would like to have a long-lasting protection, I mean, a protection that can be used for 25 years, it is better to file a design registration. Of course, your furniture should have some characteristics, should be new, should have the individual character. I mean, let's say the informed user should be aware that your product is really something original, something unique, never seen on the market before. So provided that these legal requirements are satisfied, then you can file the application. Actually, the best value for money application is the EU design. You pay only 350 euros for official fees, and you can enjoy protection in all 27 member states. Then with the EU registration that can be obtained probably in 2-3 weeks, because there are no substantive examination of the application, then you can have 6 months international protection. So you can extend your protection according to the Hague Convention in the 96 countries of the Hague Convention of WIPO. And then, so you can be protected in China, in US, and in other countries, just using the priority rights. So I think you have a lot of opportunities. International design protection is not so expensive, but you know, worst case scenario, there is the at European Union level only, pay attention, there is the non-registered design opportunity.
Thank you. Thank you. Very interesting point and very useful information. Another quick question I have in mind, because we are always thinking about internationalization as an export activities to foreign countries. What about if I found a product that could be commercialized in my own country and I found it abroad? So I would like to import a product in Europe to be commercialized. The problems are similar, are somehow mirroring the ones you have highlighted before, or could be different according to the different countries we are talking about?
Well, of course, it depends on I mean, on what are your you know, your goals. I mean, for importing, of course, trademarks protect, let's say, products coming from the originator of the producer of the product. If you are importing, of course, you should consider not to infringe any legislation, any rule in the in your country of origin, your country of destination. So in European Union, if you are in USMEs, you are importing goods, you should let's say, be careful not to infringing any IP right of third parties importing products in European Union. In case you like to control, for instance, this is another problem. In case you like to control borders, to control, let's say, the borders of European Union from importing products that can infringe your rights, you can file this application for action before the EU customs. In particular, the UIPO offers also the enforcement database that is a very important, interesting tool aimed at facilitating the filing of application for action. And so in this case, you can control the borders against any importing activities that can infringe your IP rights. So it depends on you know, your objectives. But in any case, let's say for exporting, for the producer exporting products are well, is the more, let's say, dangerous activity in terms of IP.
Perfect. Thank you very much. Thank you very much. We will follow up this webinar by sharing with our participants to the training course your presentation as well as the recording, so that if you have additional questions, please rely on us. The next webinar will be on the 10th of July, but you will receive by mail all the information in due time. Thank you very much and have a great day ahead.
Thank you.